So, can everybody see the shared screen right now? We're good. Okay. So, so this presentation is for commercial tenants and landlords. It's not for residential tenants. And of course, I have to say that, this doesn't constitute legal advice. It doesn't make anybody my client. If you want to be my client, you can email me. We can set up a time, but everybody's circumstances are very different. So, what we may say in the presentation may kind of sort of apply to you, but it may not apply to you at all, or it may be very specific. So I think right now, the kind of questions that I'm getting are the kind of questions listed on this first slide. People are asking, should I renegotiate my lease? I'm not earning as much. So if I'm not earning as much, I can't pay as much rent. How's a landlord going to think about this? What types of options are there? We're hearing about forbearance, we're hearing about deferral, we're hearing about modification. I had one client say, maybe now is just time to retire. Maybe it's time to just be done. Is this a good time? How do I get out of my lease? Another person said, I need more cash flow. We're optimistic. Can I bring in a new partner? Should I assign? Should I sublet? I have a personal guarantee on my lease. Are they gonna go after me personally? And then of course you and I have the discussion of, why might a landlord be willing to do certain things or not be willing to do certain things for you, and why might a landlord be able to do certain things or not be able to do certain things for you. So so that's kind of the perspective that I'm sharing. It's really more to lay groundwork and to give some perspective. So I'm going to move to the next slide, assuming I can move to the next slide. Hold on, let me see if I'm having technical difficulties. Oh, there we go. So before people approach their landlord, before a landlord approaches a tenant, I wanted to kind of go through a timeline. And the thing you do is figure out where you are. I mean, any good negotiation entails knowing where you're at and knowing where the other party's at as well. So in terms of looking at your leases, if you are a retailer, if you are an office tenant, if you are an industrial tenant, the first thing that I ask is, how far into your lease term are you? Like, do you have 1 year to go? Because that's going to color a discussion, in a way that I have 10 years to go is not going to color that discussion. So, do you have extensions? Do you want to stay? How's your business doing? Did the landlord put a lot of money into your space, or did you put a lot of money into your space? I know I have, a bunch of restaurant clients, and they put a ton of money into their spaces, between their equipment and their decor and, and their marketing and things like that. So, another thing is if a tenant's approaching a landlord, if a landlord's approaching a tenant, what is the tenant's payment history? Like, have you had a good relationship with your landlord? Are you paying on time? Or are you always paying late? Because that obviously colors a decision about whether somebody wants to work with you or not. Then the next thing I say is, what does the lease say? Because people ask questions, but it's really all about what's down on paper. And I've gotten a lot of questions about force majeure, which is why I put it in front, as number one. Force majeure is a clause that your lawyer hopefully negotiated in, but it has perhaps limited effectiveness. And what it says is, if X, Y, or Z occurs, then your performance is suspended. Sometimes it says your payment, but not your performance is suspended. And so force majeure things tend to be acts of terrorism, acts of war, governmental order, which comes into play now. Is there a governmental order? I can't perform, but can I pay? So force majeure is an interesting clause. I always like to add at the end of the clause that if it's some occurrence that prevents performance that is outside of the control of the tenant or the landlord, depending. So clearly the pandemic falls outside of that. With that said, you never want to litigate a clause, and certainly not now. I mean, the whole world is kind of in the same position. And so rather than going into that particular provision, I wanted my presentation to be a little bit broader. So going into what does the lease say? Again, is your lease about to expire? Maybe you just say, hey, landlord, I'm done. Do you have an extension? And you say, well, maybe this is an opportunity to extend and renegotiate a market rent. Who knows? Does your lease treat your rent as all inclusive? Meaning, you pay rent and then the landlord pays, electric, common area maintenance, their operating expenses, their taxes, and their insurance? Or does your lease say my base rent or my minimum rent is X, and then on top of that, I pay X dollars a month as my proportionate share of, the building costs. I pay my own electric, things like that. So you want to know what your lease says, and we'll see on the next page, why. Do you have a personal guarantee? Most leases for, mid-sized businesses, small businesses have a personal guarantee. Sometimes the quote unquote personal guarantee comes from a corporate entity. That might be, in a franchise situation, you may have both a corporate guarantor, or they're willing to step in. It may be an entity guarantor, or it may really be you and your bank account. So how do you treat the personal guarantee? Because, if you set up a nice LLC to rent a space, now they could say, hey, look, you're not performing. We're looking to you personally. Are there ongoing construction obligations? Is something in the middle of happening that, you need to discuss either on the landlord side or on the tenant side? And then are there co-tenancy obligations? That's really more common in a shopping center context than in, our local retail context. And that would be, well, I'm not obligated to operate if Stop and Shop is not operating, and it might be in your lease if you negotiated that in. If you're relying on foot traffic and X number of businesses are closed, you may have a provision. You may have said as the tenant, hey, if all these businesses are closed, I don't want an obligation to be open. So with all of that said, where you stand with your lease, where you've stood with your landlord. Now looking forward, I'm going to sort of describe what I, as a landlord, would think would be a good presentation to me if you're coming with an ask. And I always would tell, my tenant clients, anticipate that your landlord would want to see this, and it also makes you look good. So if you have historical financials that show where your business was trending beforehand, where you had expected to go, before you go into a landlord, have those ready, because that will be an ask. If you now have taken the time as a tenant to say, wow, what is my business going to look like? If you've done a new business plan or you have new projections, and it could be something as simple as my business is at 50% of X, whatever quarters it was beforehand, but have those projections, have those pieces of information. Obviously, they're going to be imperfect because no one expected a pandemic. We don't know how this is going to unroll. We don't know whether we're going to have a second wave or a third wave. We just don't know. But having a plan is always a good thing, and you could do different scenarios. If we're open by June 1st, if we're open by June 20th, if we're open, this is where I would hope to be and where I would expect to be. And you're, of course, guessing at what, the consumers are going to do. Key dates, if you actually have key dates, guidance, which obviously we saw, and I actually have represented several hair salons, interestingly enough, one of which unfortunately is closing. But if you have key dates, like this is the date upon which I will be allowed to open, that's an important thing to kind of have in your discussion with your landlord. Looking forward, you may also be saying, as a long-term plan, I was planning on retiring in X number of years anyway, or my kids no longer want to take over this business, or my partner no longer wants to take over this business. That's also part of a plan. How long do you want to sustain for? And was it your intention to wind down anyway? And do you want to accelerate that? Or, Do you want to bring in a new partner? Maybe somebody wants to be substituted out, mom and dad are done, or my partner's like, okay, I'm just going to move to Florida. I've had enough. And somebody else is coming in. So looking forward, is it time to close? Is it time to do something else? And how long do you last, if this lasts? Are you taking money out of your own pocket? Is it partially from your business? And then finally, on the looking forward part, I think if you've invested money in a space, you should be speaking with your accountant. You're like, okay, do I have losses that I could take from the business? Do I have losses that, that I can write off? Have I been depreciating something? Can that be accelerated? I'm not a tax attorney and I'm not an accountant, but those are things that I'm asking people to ask their accountants as well. In other words, can you help yourself this year, with taxes? Can that make the difference for you? So I'm going to go on to the next slide. And so now I'm going to flip from the tenant to the landlord perspective, because landlords have perspectives too. And while everybody does want to be accommodating and does want to help, and my landlord was accommodating, after initially having some hesitation, here's what's going through the landlord's mind, and this is what I would be dealing with if I'm dealing with a building owner. And we're dealing, potentially with their lender. So let's say they have a mortgage on their building. They have, a note and a mortgage and a loan agreement, and they have documents and things like that also say, if I'm not paying by, the first of the month plus a 5-day grace period or a 10-day grace period, then I'm in default. And they have covenants in their documents that they have to satisfy. So a debt service coverage ratio, for example, that means that they need to have a certain amount of income coming in or revenue coming in relative to their debt. And if you fall below that, they may be required to put additional money in reserves because the lender is concerned that they won't be able to pay their mortgage. Is there enough money coming in to pay their taxes? So they have ratios they're looking at, their property valuations. So one of the ways that, a lender looks at a building is, what is this income worth? And, you do it by a certain multiple, or you compare the values across buildings and what's your property worth. And that's one of the things I was saying. I was wondering whether people were going to want to reval their properties based on new income levels, but I don't think it's that time, because I don't think we've stabilized. And then the last thing is, if you're going to your landlord and you're asking questions, you're asking for accommodation, whether within your landlord's documents, lender consent is required for any kind of modification or termination, because your documents may say, well, if you are seeking to reduce any rents or you're seeking to terminate leases, you need consent from the lender. And maybe it'll be reasonable consent, but that just means that you're not simply dealing with your landlord, you're dealing with somebody in the background that you don't know who that is. You haven't had a conversation with them. And so, that's a whole other level that may be affecting you. Excuse me, I should be taking out my emails. This is horrible, sorry. So that's what the landlord is saying. Oh boy, do I have to talk to my lender right now? And what is my lender going to say? And is my lender going to put me in default if I let you not pay? Then the other thing, the other conversation that's going on with landlords and lenders right now is, well, how long is this going to last for? Like, do we just kind of let this ride for a little while? Do we need to declare a default now? And the landlord's going to have all the same considerations that the tenant did. How's my payment history? How's my relationship with my lender? So same kind of thing. Everybody thinks that the landlords have insurance that covers these kinds of losses, rent loss insurance. That's actually big hot topic in the legal world right now. A lot of insurance doesn't cover pandemic for the landlord. So they say, oh, well, if it's, a loss, you have to have a loss, and they say, okay, well, what is your physical loss? That, you know, they like to have rent loss tied to a physical loss in the sense that, okay, the building burned down, so I have a rent loss. So you can figure out what that event is, and you can also figure out when you can rebuild. So rent loss insurance is actually kind of questionable for the landlord, so people shouldn't assume that they have it. And just like tenants have guarantees on their loans, landlords have on their leases, landlords have guarantees on their loans. And so, so the landlord is now saying, wow, you know, if X, Y, and Z tenants can't pay me and I don't have enough debt, that turns around and now that's money out of my pocket because my landlord entity, corporation, LLC, partnership doesn't have the income coming in and I have a guarantee. So the landlord's thinking about that as well. And then the question is, you know, what is the lender going to do for me? Are they going to utilize reserve sort of in the same way that a tenant says, you know, are you going to utilize my security deposit? Are they going to forbear? Are they going to say, you know, we're going to come up with one of these solutions that we're about to discuss for tenants. We're going to defer. You know, you still have some income coming in, but the shortfall has to be paid, you know, through your guarantee, meaning out of the landlord's pocket. And then the last one is kind of an interesting consideration that I think we spoke about, you know, Chris and Kate, and that is, you know, this concept of COVID claims. So a landlord's going to be saying, okay, I'm going to make accommodations for my tenants, but how well do I have to clean the building? You know, what are my guidelines? You know, what do I now need to do if you're walking into an office and you're walking through the hallway and somebody coughs in the hallway, you know, and you know, or who's touched the handrail, who's touched the doorknobs? How often am I supposed to clean? You know, what do I do with this? Because what a landlord, you know, if I'm representing the landlord, I'm going to say, well, if you're going to make a modification for your tenants, if you're going to allow some sort of accommodation, you want to make sure that neither they nor their clients or customers are then going to turn around and sue you and say, well, you know, you didn't clean the doorknob at noon and I walked in at 12:04, and if you cleaned the doorknob at 8 a.m., and somebody didn't wear gloves or somebody's hands weren't sanitized or somebody did wear gloves and their gloves were dirty, is that the landlord's fault? And we all kind of intuitively know that it's not the landlord's fault, but you know, the reality is in the world, people, you know, want to have someone to blame. It's easier to have somebody to blame, and it's not uncommon for there to be litigation against landlords generally, slip and fall. All kinds of things, you know, the snow wasn't shoveled, there was ice. So litigation is not such a crazy idea, and thinking that there could be claims for COVID for, you know, for a lack of maintenance, or you didn't space us out, or the elevator had 2 people in it, or things like that. It's not that crazy to think that somebody may want to sue a landlord, or that their customer may want to sue a landlord. So if I'm advising a landlord, I'll say, look, you need to waive any COVID claims against me for yourself and for your clients, because I don't know any better than you do these days, you know, what's supposed to happen. So that kind of gives you the perspective, you know, from the landlord side. And so now you know what you're negotiating, you know, now you know what, you know, now you know why if the landlord says to you, I really can't do that, or I don't have an answer for you yet, it's going to take 2 weeks. It may be that they don't feel like doing it, but it may be that they're turning around and they're speaking with their lender and they need some time. They need some time as well. So, so if you don't get a response immediately, that could be the why of it. Okay, so moving right along. So now let's talk about different kinds of solutions and different kinds of perspective. There's a concept called forbearance. People are seeing it, you know, now in mortgages. There's, you know, there are legal issues surrounding that, and every 5 minutes that's changing as well. You know, what do lenders have to do? What do insurers have to do? What does everybody have to do? But basically in forbearance, it means that you already have a default. And a default means somebody didn't pay, somebody didn't perform, you know, the thing that was supposed to happen didn't happen. And the cure period that they were supposed to have, you know, if you have 5 days for a payment or 10 days for a payment, it wasn't paid within the 5 or 10 days. If it was, you need to maintain insurance and, you know, you have to do it X number of days after notice, that period has passed. So there's actually a default in place. And it can be declared, you know, the landlord could send you a notice saying, hey, you haven't paid, which they're not required to do because you're supposed to know you're supposed to pay, or hey, I haven't gotten the insurance certificate, or some other thing. You were supposed to comply with some legal requirements and you didn't. And you had a cure period and you didn't cure. They may have sent you a notice. They may be letting the default sit because they're figuring out what to do when they haven't declared it. And then, one of the questions on forbearance is it really solely due to the pandemic? And so, if you were already in default before and not paying your rent, that will guide whether somebody wants to provide you with forbearance, and a forbearance agreement would look something like, we won't declare your default, we won't act on your default so long as you are doing X. And so it could be, you give me a payment today and for X amount of time, I'm going to waive, lower, suspend, do all kinds of things. But on X, Y, and Z date, on a date certain, I expect you to be fully performing. And then if you don't, the default, the default goes live. In other words, the default never actually went away, but they simply said, we're going to give you time. We're not going to act. We're not going to, and I don't even want to go into evictions because that's so complicated right now. A, because, courts aren't open for them, and B, because once they are, they're going to be backlogged, and because there's a difference between commercial and residential. And so we're not going into those topics right now. So possible solutions. So forbearance just means, okay, we're going to stop doing X, Y, and Z. You obviously want that in writing. You want it documented. You want it properly documented. An email's okay. A document is so much better because you never want to say, well, there was a misunderstanding. Misunderstandings are always a bad thing when it comes to, accommodations. So there's things that you can defer and suspend. So if you have that minimum rent, but you're also contributing to the landlord's taxes and insurance, or the operating expenses of the building, or, you pay X percent, of their operating expenses because they're providing your snow plowing and they're doing various other things, they're doing the building repairs, you should know what you want to defer or suspend, and they should know what they would be willing to defer or suspend. So maybe you suspend for now and you add more rent on once you resume doing what you're doing so that you're making up that, difference. Maybe they want you to just pay a certain sum now. Maybe you want them to apply your security deposit or a portion of your security deposit. But you need to know what you're asking for. So if you have a minimum rent and you have operating expenses, taxes, and insurance, one thing that I've said to one of my landlord clients is, well, I know the tenant wants to suspend their rent, but you still have to pay taxes and insurance because otherwise you can end up with a lien on your property. Now the town has a lien on your property and you don't want liens because that defaults your mortgage and then you're done. So can the tenant just pay the taxes and insurance portion that they're supposed to pay that's not part of minimum rent? Or can they pay 50%? And that may have to do with, again, what period of time, but also, is there a governmental order? So is it impossible for me to use my space because I really am not allowed to be there? Is it impractical for me to use my space because, I'm able to do X, Y, and Z in the space, but my space isn't configured a certain way, or or because you're compromised, or because your clients are, because you're a medical office and you have patients who are compromised. And what's sort of the realistic business timing to come out of things. So you want to figure out what you want to defer or suspend, whether you want to add it on to the rent later, whether you're just asking, hey, can we do 50%, or we'll do 50%, and as soon as some event occurs, I'll pay you back. The other one is maybe you're asking for a permanent rent reduction. In other words, you're not saying suspend it, you're saying I can pay 50% and I can pay 50% now and until such time as this order is lifted and I can open my restaurant, permanently and fully. So, that may be a question. And one of the things that I would expect the landlord would ask and that the tenant should anticipate is that They're going to want financial reporting, like how's your business doing? In other words, don't take advantage of the pandemic. If your business is doing great, don't ask me for a rent reduction. Please provide quarterly financials or at least a status update or something like that to let me know how you're doing, because you want to maintain good relationships with your landlord and you don't want to ask for more than you need. The next concept is it time to terminate the lease? Has this been a great tenant and you want to keep the tenants? Has this been a great landlord and you want to stay in your space? Maybe you hate the space. Maybe you hate the landlord. Maybe the landlord doesn't like you. You haven't paid your rent. Maybe now is the time to negotiate a mutual termination. And one of the reasons why that's a good thing sometimes is because you don't want it to be an eviction. An eviction ends up being in the public record. So if I look up litigation and I look up, XYZ entity, I could see that a landlord sued for eviction. I just have to go on the court system. And so, the question is, do you want to just mutually terminate and there's no public record of it and everybody says, it's just time to move on. Somebody maybe wants to go to less expensive space in the future because they realize, business is changeable. So maybe it's the time to terminate from the landlord's point of view because they had a tenant that wasn't paying rent to begin with. Maybe you want to terminate because you would have terminated you would have been done anyway in July, and maybe you could say, let me terminate early, and everybody goes their merry way, and tenant may want to find less expensive space or may want to close. Terminating doesn't necessarily mean that it's a business failure. It could just mean it's time. It's time to move to a different place. Then the other thing is taking on a business partner or signing and subletting. That's one way to get cash infusions. It's one way to change the nature, of a business, to change the nature of your cash flow. Maybe you've been in a space and you've wanted to change it or upgrade it or bring in a partner anyway. And so, what would that cash infusion be used for? I would tell my landlord, I'd like to use it. I'll pay you the rent with this new partner's cash infusion. And we'd like to rent and remodel because the space is closed anyway. So why not? If we want to do it, now's as good a time as any. Maybe you want to change the nature of the business slightly, which the landlord would obviously have consent over, but maybe they want an upgraded business in their space as well. And then, is this allowed under the lease? So if you're just bringing in a financial partner, sometimes they say, well, if you transfer up to X percent of your interest, 20%, 30%, 49% of your interest in this business, and we don't care because you ultimately maintain control and financial responsibility. But usually the landlord has consent rights over that. And usually when you bring in a partner for more than a small amount, the landlord's going to be like, okay, well, that's just another person to have on a personal guarantee, which it makes sense since they're responsible for the business. So, so that's sort of one of the things that you may want to consider. A lot of places don't have assignment and sublet rights, but they may have it, with the landlord's discretion, and the landlord may want you to do that because they want their rent coming in. So again, something to think about. On the personal guarantee, this is something I've gotten questions about quite a bit. Is it a full recourse guarantee? In other words, there's lots of different types of guarantees, and it depends on what you've negotiated upfront on day one. So your guarantee may be a full guarantee of payment and performance. So essentially, you're the tenant. You owe the landlord XYZ, and you need to do whatever the tenant needed to do. When I negotiate my guarantees, I like to try to limit them. If I'm representing a tenant, either in time or in amount. So I could say my guarantee continues for 3 years from the date I've started the lease, and then the guarantee burns off, it goes away. So that's limitation in time. If you have a personal guarantee that's limited in amount, there's a concept of X number of months rolling. And rolling means I pay my rent through the date that I leave, and then I pay an additional 12 months, 18 months rent. And so your guarantee is capped. So if you have 5 years left and you leave tomorrow, you owe them rent through tomorrow plus 18 months if you've had a rolling, as opposed to having a full guarantee where you're responsible for everything, all the rent through the end of the term, because one of the landlord remedies, excuse the dog, one of the landlord remedies is to accelerate the rent. You know, if they default you, hold on one second. Scott, hi, sweetheart. You're very nice. Well, lie down. So, so your personal guarantee, and then the other thing is if you have a partner, you know, if you're two people on a personal guarantee, most personal guarantees are joint and several. And so that means I can go after everybody for 100% and you work out amongst yourselves. Like I'll collect from whoever has money if I'm the landlord, and you guys work it out amongst yourself. And hopefully if you've had an operating agreement done well, you know, you are never liable for more than X and the other person, you know, has to contribute. So going on to the next slide. So some of the, you know, some of the subtle issues that you're going to be thinking about either as a landlord or as a tenant when, you know, when you're looking at what is realistic by way of continuation of business, continuation of the lease, and how the lease space can be used. So we talked about common areas and, you know, the doorknob or the handrail or the elevator. You know, what is your makeup of your employees or even your customers, and like what are their risks, and is this a good space for them to be in? So, you know, if you have a lot of elderly people coming in and it's a tight space, is that a really great place to be having this business right now? And how do you mitigate that risk? Who's responsible for legal compliance? Most leases say you are responsible to comply with all laws within your space. And so, you know, what does a landlord do then if somebody's not wearing masks and somebody gets sick and, you know, they come and they're like, hey, you know, your tenant's not complying. You know, I'm calling you up, I was a customer, your tenant's not complying. Well, they're responsible for complying with law. So, you know, how easy is it for you as a tenant to comply with law? Like, do you want to be operating? Is it easier for you to comply with law? If you're cleaning within your space and the landlord's cleaning within the building, you know, what are your legal requirements? You know, find out, is it possible to operate? You know, one of the questions that came up is about vents and air conditioning, because there's this thing that's circulating on Facebook, and apparently it's based on a study of COVID transmission in China. I don't know if you've all seen it, the table set up in a restaurant where there was an air conditioning and a vent system that came in from one direction, and the sick person was sitting close to the vent, and the airflow just went whoosh, and it, you know, and it transmitted to other people. So, you know, people are asking like air vents. I'm like, I don't know about air vents. I don't know if your landlord knows about air vents, and I don't know if the epidemiologists know exactly about how the air vents work. But it's kind of an interesting question. And it's an interesting question in the sense that in my office, I can open a window. So I can open my windows in my office, which makes me feel good. I don't know if I need to open them or if I want to open them or if it's raining, what I want to do, but it just makes me happy that I can. So people are asking about, you know, air vents opening up. You know, some restaurants can open up windows. That's a good thing. You know, is there a breeze? You know, some are more enclosed, so they're thinking about that. I know that there's discussion about hair salons and not using blow dryers because that makes the air circulate more. I would also think about bathrooms, you know, those things that blow air and stuff like that, that you put, you know, that creates movement of air. So, you know, how do you, and I'm talking about air vents only because people think about how they use their space and how they can use their space and where do you want to put people. So, you know, that's something you want to think about when you're negotiating your lease. Are you going to have 50% capacity? So if you have a hair salon, are you spacing people out now more? So now I can only have 2 stylists in instead of 4. Because, you know, we need the space layout to be different. You know, again, there's continuous operation. Does your lease say you have to be continuously operating? And then, you know, you can say, well, I can't continuously operate. I can only operate during X, Y, and Z times. So I think those are, you know, those are really the issues that I'm seeing around leases. Obviously, there's this intersection right now. Not only is there the landlord and the tenant talking, but you have so many more players now, because now your business doesn't just depend on your relationship with your landlord or your relationship with your customers. It depends on the medical community. It depends on epidemiologists that aren't even in your town or state. It depends on governmental orders that right now, fortunately, are at the state level. But what if there was an order at the federal level? So you have a lot of players that are coming into your relationships right now. And you also have a lot of governmental programs. So that adds other players. It's like, okay, is there paycheck protection? How much am I allowed to spend on rent? How much do I have to spend on my employees? You know, how much of this do I have to spend? You know, is there unemployment? Are the people that work for me 1099 employees? So there are so many more players right now involved in your relationships. Obviously, you focus on the ones that you can control the best, and information is changing. So while I like to say whenever you draft an agreement, you know, draft tight, you know, make sure that it's very clear what you're spelling out. Sometimes these days you're not going to be able to be perfectly clear. So I had one provision across my desk where somebody said that we have an exception for performance for pandemics and governmental orders and this and this and this. And this is a transaction that's just happening now. So my question was, well, it's day one. Does that mean that on day one, nobody has to perform? Because we are squarely in a pandemic. What's, you know, squarely within governmental orders and regulations. You know, does that mean that putting that provision into my document now, my brand new document, my brand new business, means that on day one, everything is excused? Or on day one, you can do this and you can, we don't know. And so, so you work with what you've got. And that's what I've got. So I can hopefully unshare my screen here.
Thank you very much. That was quite comprehensive. I just have two questions. One, you know, without getting into too many details, what has viewed as the tenant-landlord relationships through, say, the last 9 or 10 weeks, just as an overview?
So I think initially landlords were, you know, we're having the same reaction as everybody else. I think it was sort of the, I don't want to change anything. I don't want to make accommodation. How is that going to affect me? Because everyone wants to know how it's going to affect them. You know, it's like, you're not worried about your landlord's not worried about you. It's all about me. I think that landlords have become accommodating. I think that at this point, people are saying, okay, I'm done now. And so that's why I was saying, I think now is going to be the time in the next month or 6 weeks where people want to make decisions. So while the landlords could be accommodating, I know that the sort of more successful negotiations for tenants have been where tenants are willing to do something. So I'm willing to pay the tax and insurance and the maintenance costs, just so that you're not out of pocket for your tax and insurance and your maintenance. I'm willing to pay 50% of my rent in areas where maybe you're not paying separate tax and insurance. I'll pay 50%, I'll pay 75%. Next month, I'll pay 75%. Or once I'm back full time, I'll pay 100%. And I know that landlords have been proactively, because I have somebody who has proactively going to their lenders before the tenants even make requests and say, what are the parameters that we're going to be able to work within? I expect X% decline in rents. You know, what will you do for me? And so the landlords have been really, really proactive in making those requests of the lenders, even before the tenants have come for accommodation. And I think that's a good thing, because they want to know what they can do for their tenants.
Great. Okay.
You know, without defaulting on their own loans, if there are loans, or without violating their own governmental, you know, mandates.
Okay. And then a second question, be difficult to answer. You know, we still don't know what the post-COVID world is going to look like, and if there ever truly will be a post-COVID world, based on, you know, some things that we've had to change that will probably change permanently. What are some of the things that you're seeing now that in a lease agreement could have been in place that weren't, that moving forward you would definitely make sure is addressed?
Landlord perspective or tenant perspective? Or both?
Give one
so let's start. Okay, so From the tenant perspective, I would like to see a force majeure provision that is broad enough. That's the provision that says I can suspend my performance during a period where things are out of control. I'd like to see one that's broad enough that it could cover these circumstances. I think the reason why that's an imperfect ask, though, is that normally when you think of that, you think of there was an earthquake, there was, a bombing of the World Trade Center, there was, something happened, the building burned down. We don't know what that timeline is, and since force majeure only acts through the duration of an emergency, we don't know what that is. But I'd still like to see it there because it gives you a starting place to talk. I'd also like to see, for lack of a better term, I'd like to see tenants read their leases before they just sign, or read their guarantees. I love when guarantees are limited guarantees. I'm like 3 years, X number of months rolling. A landlord should be able to relet your space in 18 months, and if they relet it, we have a provision that says you've now leased it to somebody else, my guarantee is terminated, or things like that. I'd like to see people thinking about limiting their obligations to a period that's realistic for the landlord, but not just signing whatever is put in front of you, because 99% of the time what's put in front of you is not good. Like, it's not from your perspective. The landlord's going to have a landlord form of lease, the tenant's going to have a tenant form of lease. If you're a powerful enough tenant, you will have a good tenant form of lease. I'm sure Stop and Shop has its lease that says, here you go, landlords, this is my lease. Or Lowe's comes in and says, this is my lease, landlord, do you want me as a tenant? I'm a really good tenant, I'm a national corporation. So I'd like people to actually really, really read their leases, and if there's something that feels wrong, there's probably a happy medium somewhere where it's not quite as extreme. So that's from the tenant's perspective. From the landlord's perspective, I think that the remedies that are in leases are pretty sufficient. I'd like to see from the landlord's perspective, now that I think about it, now that we're thinking differently, is certain waivers by tenants. You don't want a landlord to be sued because there's some governmental regulation in place and the tenant says, wait a second, you're preventing me from operating my business. And the landlord's like, I'm not allowed to open this building. I'd like to see that relationship be smooth, so that if there's something that the landlord can't do or shouldn't be doing, that they're not going to open themselves up to liabilities. Kind of like the sidewalk thing that we're talking about right now. I'm like, ooh, is that going to be the tenant's insurance? Is that going to be the landlord's insurance because they want businesses open? Is that going to be the city's insurance? Like, I'd like to see some, flexibility in that area. And then the landlord has a whole other set of issues because they have their loan issues and they have their partner issues and things like that. But that's kind of a different presentation.
Okay. Any other questions? Okay. Well, for you guys, in closing, I want to thank you for this. I certainly learned a lot, and this will certainly help me understand some of these things as we get approached with questions. But if anybody wanted to reach out to you, feel free to give your contact details so people could connect with you after this.
Yep. So if you've had the share screen on, my contact details were in the upper right. Do you want me to share the screen again? I'll hit share screen.
You can also say them verbally too.
Okay. Yeah. So I'll just give you my office number. The office number is 860-836. Actually, that's my cell. I'm about to give you my cell. 860-236-0441 is the office number. It is bouncing to my cell.
Okay, great.
Wait, no, I just gave you my cell again. Wow. 236-0600 or 836-0441.
Okay.
Can you tell that I'm getting brain fog from the pandemic too?
You don't call yourself a lot.
I never call myself.
All right. Well, thank you very, very much for this. And just a reminder to everybody, we will continue this series as topics come up that we feel are important to the greater business community. And you can learn about those at whchamber.com. Thank you.
Thank you very much.
Thank you.